Senator.
Can we request no chairs? Because this is, having been at the State House, never served with you, it enhances more rapid delivery of testimony. So anyway, thank you. So,
I'm like one of my colleagues.
thank you. Just one moment.
Sorry, Senator
Commissioner.
Moore. So before we begin, I just want to ask Madam Chair if you can request those who come up to testify to state sort of the subject that they're testifying on behalf of. Because I think we're all taking notes and just will be easier going forward.
Okay. All right. Thank you. Sorry, Senator Moore. Thank you.
All right, Senator Michael Moore. I'm speaking to the change in the regulations that on the, I guess, the hiring requirements or prohibitions. So good morning, commissioners. Thank you for the opportunity to testify on the proposed regulatory changes. I greatly appreciate the time and effort you and your staff have put into drafting these regulations. My testimony today follows up on a letter I sent to the CCC in early August on the impact of the proposed changes that the proposed changes will have on the agent suitability standards and the potential for sex offenders to become retail or delivery operator agents. As you know, back in 2017, the CCC first implemented the current mandatory indefinite disqualification on those who were convicted of a sex offense from obtaining registration as an agent. As a rationale for that decision, the CCC observed that the retail agents have direct access to customers and their personal data. Because of that level of access, the CCC determined that the retail agents should be subject to higher suitability standards. The draft regulations before the CCC abandon that higher standard. This change under consideration would also allow operator to deliver operator agents. I think it's unfair. I think it is fair to say that no one should have to open the door or their door to a registered sex offender. Also, the change that was made legislatively to the standards allows for the prohibition of a minor, someone who was convicted of the distribution of a controlled substance, including marijuana, for being employed in one of these positions. But it doesn't restrict someone who could be a level 3 sex offender from filling one of these positions and actually going to someone's house and delivering the product. I find that a horrendous loophole in the law, the fact that we would possibly allow a sex offender from a level 2 to level 3 to actually go to the premise of someone who could have been convicted of raping a child, raping a woman, or just rape in general, or some sexual offense. While I generally support removing barriers to entry for employment in the marijuana industry, I believe that certain safeguards need to be maintained. I am asking the CCC to consider a mandatory indefinite disqualification of individuals required to register as a sex offender for agent suitability. Whether someone is required to register and their classification level is a decision made by the Sex Offender Registry Board, and that decision is an independent civil determination made by the board outside of the criminal process. This prohibition already applies to individuals who hold a license, and I ask that the CCC apply the same prohibition to agents of a licensee. I understand that the CCC intends to rely on a catch-all provision to protect the public health, safety, and welfare. I'd like to know what that means if there's an issue with not being able to look at someone's criminal conviction. However, this catch-all has several shortcomings. First, it's independent on complete and accurate reporting by the employer during the agent registration process. Second, it is subject to agency discretion, and it's unclear that the CCC will actually use it to exclude those required to register as sex offenders. Finally, it is limited to the preceding 5 years. As a result, if someone commits an act that possesses a risk to public health, safety, and welfare, but it occurred outside the 5-year window, the catch-all will not apply. The CCC should also consider strengthening the catch-all provision in its application. And just to reinforce my position on the civil process aspect of this, if you go to the went on the website this morning for the SORB, and there's a sex offender classification process. And clearly on the first page of it in the preliminary classification, there's one section that says the board, this is the Sex Offender Registry Board, the board member then issue a preliminary classification level recommending the offender be a level 1 low risk, level 2 moderate, level 3 high. The level speaks to the danger and risk to reoffend. To me, I think that goes to the catch-all. That you should be able to apply the standard so that they will be indefinitely prohibited from these positions. Also, in the classification hearing section, there's a section that says the hearing is conducted by a single hearing examiner who may also be a board member. The hearing examiner takes an independent view of all the materials and the factors to be considered. Unlike the criminal process, clearly showing this is not part of the criminal process or the conviction. The Sex Offender Registry Board hearing by law is not open to the public, including victims. There's also a section again, going to the catch-all phrase, we have a section in the level or the levels of the sex offenders. There are 3 levels of sex offenders in Massachusetts. Offenders are classified based on their risk of reoffending and the degree of danger they pose to the public, which again, I think fits again into the classification, the catch-all for public health, safety, and welfare. Then it goes, a sex offender is a person who lives, works, or attends in school in Massachusetts, has been convicted of a sex offense, has been adjudicated as a youthful offender, or as a delinquent juvenile, as a sex offense, and the important thing here, been released from incarceration, parole, probation, supervision, or custody of Department of Youth Services for a sex offense conviction or adjudication, clearly taking it out of the criminal process.
Senator, if I could just, only because we're holding other people, and we've given out of courtesy.
Okay. Yep. No, thank you very much.
No. It's been very, and one of the things I wanted to ask you before you end your written testimony, because I know that there's some issues of sort of the legal nuances here. If you have a legal brief that you could share with the commissioners, so we could have benefit of the legal arguments that you're making, because I do know that there are some questions on the sort of the legal nuance of this. If you have a brief that you could share with us, that would be helpful. And I don't know if you have that available.
We don't. We just actually, after the letter, we just prepared this
Okay.
testimony for you.
Okay, all right, please, thank
I
you.
know questions are trying to keep to a minimum.
Yeah.
But this is a serious topic, and I
Right.
do have a couple. And Senator Moore, thank you for your testimony today. In light of the current statute, does the CCC have the legal authority to prohibit individuals required to register as sex offenders from serving as retail or delivery operator agents in light of the statute?
Well, I think yes. Under the CCC under Chapter 94G has the authority to set minimum standards for employment. While recent legislative changes have changed the option and removed the option, most cases of utilizing a prior criminal conviction or other criminal case disposition as a basis for the disqualification, the CCC can still base disqualification on the Sex Offender Registry Board's independent determination as part of the civil process. So, just basically.
So in your opinion, yes?
Yeah.
Okay. Does this type of exclusion exist anywhere else that you're aware?
Yes, you also have, if you look at Uber, Lyft, some of the other I want gig economy type of jobs, they all have these restrictions in there that they run criminal history checks, and they do a SORB check, which is also separate from the criminal history check, further I think further supporting our argument that this is a separate process from the criminal conviction.
Okay, and I just have one more. Thank you, Madam Chair, and thank you, Senator. With the public health, safety, and welfare, that catch-all phrase, would it address this issue?
Well, I think it could. If it doesn't, then I really don't know what that phrase could be used for then. If you got that for public health, safety, and welfare, and I just referred to the language that's in the SORB website as far as their process and the classifications, and it talks about risks to the public and danger. So if that catch-all language does not apply to what I'm talking about, then I would ask you, what does that language apply to?
Okay, any further questions?
Thank you.
I just want to say thank you. I know you've been really attentive to the work that we've done here at the Cannabis Control Commission, and
Thank
it's
you.
a topic that I read your letter thoroughly, so I appreciate your input. I just want to say thank you.
Thank you very much.
Thank you very much, Senator. Anybody else? And again, obviously, this is, I think you have done a great job in following up on this issue, and we appreciate your time, and thank you for sticking to our time rules. We appreciate that.
I tried. Thank you.
Thank you.
Thank you very much.
Thank you.
Again, next up, we have Nicole LaChapelle, the mayor of my hometown, East Hampton. I don't see her here. She is not here. No, okay. Sean Suhosky. He is the town manager of Athol, but more importantly, the son of my seatmate in the legislature many years ago.
How are you,
Good morning.
Madam Chair, members of the commission? What a great morning, huh?
Thank you.
I'm writing a sternly worded letter to the air conditioning vendor. I'm Sean Suhosky. I am the town manager in Athol. We have 11 enterprises that have gone through local approvals, and I'd say 4 or 5 of them have been through the licensing approval. The others may be pending before you. My position today, I've submitted written testimony on a couple of occasions, and also in my prior capacity as chair of the Small Town Administrators of Massachusetts. The concerns that I've heard from my colleagues are that the goalposts are being moved. It's an after-the-fact rules are coming into effect that would affect our contracts that were negotiated in good faith, and many times with corporate interests that have budgets that quintuple the size of the entire town budget. So this is arm's length, if you want to call it that, negotiations, mutual agreements and contracts, and we're very concerned in looking at the draft regulations that all of these contracts, which would have sunsetted in 5 years anyway under the prior law, now will be subject to a state agency review for new rules, to comply with new rules. My point today is that cities and towns need a predictable off-ramp from these contracts. So does the industry, so does your commission, right? Wouldn't that make life a lot easier than wondering if we're going to have 600 lawsuits? I feel that municipalities were painted in a bad light because of a corrupt mayor that makes headlines everywhere. Well, that's not the colleagues that I know. That's not what local officials that I am familiar with do. They're looking to stimulate business, but there was also a bargain for exchange. These communities, Athol included, and my elected board included, did take the promise of an economic benefit, and our staff then went through a process to develop an application procedure, amend our zoning bylaws to welcome an industry that was previously illegal in the Commonwealth, still remains at question at the federal level. So I just want to speak up for cities and towns and say, if there's something in the old contracts that's unconscionable, anybody can sue us. You know, there's a couple lawsuits pending. We should not be changing the rules after the fact. And I want to add one more piece to this. We had a state senator just spoke. Before enactment of Chapter 180 of the Acts of 2022, There was a House, obviously, many House versions, many Senate versions. And as they come together before they get enacted, there was a specific piece of language. It was the last sentence in the language. This law will become effective. It was going to be retroactive to 2016. The legislature took that language out in the final bill, in the final law that was signed. That tells me the legislative intent was that this not be retroactive. And I've seen other correspondence from state legislators that you have as well that will back that up. Aside from that, we have some great operators in Athol, and I'm very curious and pleased to see the commission working so hard on a new industry to come up with the equity provisions. We just need to protect the contracts or find an off-ramp for all of them, the cities and towns as well that are hosting these facilities. So thank you very much for your time.
Appreciate it. Thank you, Sean. Thanks very much. And again, I'm going to try to keep us to the 3 minutes. You were good, but just making sure everyone knows that tiny little like minion looking thing there is the timer. And so that's what you need to kind of keep an eye on. And when I start looking like this, just understand I'm panicking.
Madam Chair,
Please.
just maybe to use the baseball analogy, as you call up the next speaker, maybe notify
Yes.
who's on deck,
Yep, yep.
who's grabbing a bat in the dugout.
Oh,
They
I
can use
can't
that.
imagine you raising a baseball analogy. Thank you very
And
much.
Madam Chair, may I also add, if folks could lean into the microphone and speak, you see the difference?
Yeah.
So if you could do that, I guess some folks are having a hard time hearing you virtually.
Hold that down at all? I don't know. Does it make sense to maybe pull it a little closer to the front? Is it taped on there?
Is it on?
Because I'm a short person and that,
Yeah.
well, that might. All right, thank you. Next up is Ally DiMatteo. And on deck is Shalene Title.
Thank you
Thanks,
so
Ally.
much. Thanks for having me here. It's good morning, everyone. My name is Ally DiMatteo. I'm a legislative analyst with the Massachusetts Municipal Association. Thank you so much for the opportunity to testify before you today on behalf of cities and towns regarding CMR 500, adult use of marijuana draft regulations. As you know, I'm joined today in person by Sean Sahosky and remotely by Mayor Paul Broder, Mayor Lungo Kern, and Town Administrator Douglas Lapp, who will all be testifying virtually. First, I want to be clear that the MMA and those here with me and the many municipalities who have recently sent letters on these draft regulations share your goals in creating statewide equity in the industry while allowing it to continue to grow. We see good intentions behind these draft regulations, and I really believe that we all want to get to the same place, but we do not see these draft regulations as the way to get there. We are continuously frustrated by the language, the retroactive language in the regulations, subjecting hundreds of existing HCAs retroactively, despite being negotiated in good faith. This was not the legislative intent of the law, and I know that several legislators have already submitted and reached out to the commission to clarify that. The commission has the opportunity, a choice, to address this and accommodate existing HCAs, allowing them to sunset while also ensuring new rules moving forward adhere to the changes of Chapter 180. Oops, sorry, I lost my notes here. However, if the commission moves forward as is and actively chooses to forego a two-tier approach, do we think it'll catalyze the Commonwealth to meet the shared goals of equity and in the cannabis industry? I don't think so. It would welcome extensive and costly litigation. The contract clause of the Constitution is clear, and we anticipate having this issue continue in the courts will only set back the gains we are all committed to in the industry to right the wrongs of the war on drugs. This will instead hinder the growth of new licensees, stifle equity, and only help the current multi-state actors who currently dominate the industry. We've submitted extensive comments as well as a redlined version of the draft regulations, and I'd be happy to have further conversations on this issue. I know you come with this with good intentions, but we urge you to fully consider our concerns very carefully. Again, we share your goals to promote equity in the industry and believe there's a continued opportunity for it to flourish in Massachusetts. I ask you consider the comments of myself and my colleagues as good faith actors who have embraced the industry and want to see that relationship continue. Thank you.
Thanks so much, Ally. And Shalene, and then after Shalene, title is Grant Smith Ellis.
Good morning.
Hello, good morning.
I'm Shalene Title. I'll be speaking about municipal equity. I want to say first off that I thought the draft was very thoughtful and very well done overall. So kudos to you and to your staff. I want to talk about municipal equity because I think there are a couple of simple to address but critical issues. And I've met with the chair and Commissioner Concepcion about that. I've submitted written comment as well, but I do think they're critical, so I appreciate the opportunity to address you all formally in person. So the first thing is that for cities and towns that are not presumed compliant under the regulations, they have to create an equity plan, goals, programs, measurements, all appropriate. But what's missing is a process to review and approve those plans initially, as well as every year or periodically to make sure that the data is being collected and the plan is proceeding. And I think it's very important for the public and for municipalities that are watching this process to be able to observe this. Secondly, I think the presumption is excellent. That is totally consistent with my 5 or 6 years of talking to municipalities. As the previous speakers have said, they share these goals. And I've heard a lot that they just want some guidance, right, and some clarity. And so I think that if you are able to provide a model ordinance rather than describing the ordinance as in the draft, you can define some of these terms, you can provide some consistency and clarity. I think it would also be a lot of work to review every ordinance and bylaw and see if it's matching up with the way that it's described in the draft. I think also a model ordinance could provide some consistency for data collection as well, and you'd be able to compare into the future, and it would be great for the research team, I think. And then finally, this is a small but important tweak. So under the presumption, there is a one-to-one equity basis that's described. And the way that so it's general versus equity, the way that the equity applicant is measured is described as a local approval process being completed, but that isn't defined. And I think it would cause a lot of confusion if that's being defined in different ways. So instead, I would recommend measuring it by when the equity business commences operations, because it's clear, it's consistent, and you have access so you can verify that date as well. And I think that would help both the one-to-one basis and the presumption to be more effective. So those are my changes. Again, thank you so much for your work and the opportunity to speak.
Thank you so much. Grant Smith Ellis, and after Grant Smith Ellis is Matthew Duncombe. And again, if you could sort of start making your way when you see the little yellow part of the minion there lighting up.
Hello, commissioners. Oh, thank you very much for the time today. My name's Grant Smith Ellis. I'll just say I'm here in my personal capacity, and yes. How about that? Yep. Okay, I just can't bend over that far. Thank you for the opportunity to be here for today. I feel a little bit like Commissioner Stebbins, and then I can say I'd like to echo everything that former Commissioner Title and Senator Moore said, so that gets that out of the way. But I also want to importantly echo that I do think that the process that led to the development of these draft regulations was deliberately done in a way that was informed and in line with the statutory requirements. In particular, in regards to host community agreements, I think it's important that the public and everyone involved with this process understand it wasn't just one bad actor in Fall River. Subpoenas went out to a number of cities and towns about their behavior related to the HCA process. And because of a single vote in, I think it was 3-2 in September of 2018, this commission was not reviewing those host community agreements for compliance with the law during a period that was no less than 36 months. So for cities and towns to now say, well, don't look back at that 36-month period. Those were just freely negotiated contracts protected by the Constitution. No, They were contracts negotiated sans oversight by any level of elected or appointed state government in the Commonwealth of Massachusetts. And they absolutely should be reviewed. And if you don't want them to be reviewed, cities and towns, I want to know why and what you're hiding, which further incentivizes reviewing them. Going forward, as to the agent suitability provisions, I'm reassured by what I heard in the colloquy between commissioners, the chair and Senator Moore earlier regarding the catch-all provision. And I do think Senator Moore makes a very strong point about the ongoing nature of the civil determination as to a sex offender's status. So even if the catch-all provision is limited to 5 years, that status has not gone away and is perpetual. What I am concerned about, though, is whether the catch-all provision would cover an unregistered sex offender, because I'm not sure specifically whether the failing to register is a civil or criminal issue, and clearly failing to register should be considered just as serious a threat to the public health as ongoing registration. And I'll end there. Thanks very much for your time.
Thank you. Matt Duncombe? Matt Duncombe? Is he here? Matt Duncombe? Going once, going twice, if Matt is not remote. Anyway, next is Lucas Thayer, and after Lucas Thayer is Alyssa Noah.
Good morning, commissioners. Thank you for hosting this hearing. Thank you for hosting me to speak. My name is Lucas Thayer. I'm a Tier 2 outdoor provisional license applicant. I'm also in the social equity program. I think it's a cohort number 2 that I was in. And HCAs are extortion, the way that they're put together right now, the way that municipalities bully operators, whether it was during that 36-month period where they weren't being reviewed in what they were doing or afterwards. It's too much what municipalities require. It's also too much for operators to be required to pay rent at their facility for months and months and months and months, a lot of money with no plants in the ground and no money coming in just to get that and the architectural review and the final license and the commence operations. All that stuff is months and months and months of rent that goes towards the cost of the operation, but really it gets passed on to the consumer. The consumer is the one that pays those months and months and months of rent. That's why the stores have weed that's too expensive right now. That's why the public laughs at the idea of the stores and their weed, which is too expensive, because all these people have been paying so much out in rent and lawyers' fees and architectural review fees and site design fees and fees for the fact that you had to pay the fee. There's way too much barrier to entry in this industry, especially for social equity applicants and economic empowerment applicants. The legislature mandated that you folks give SE and EE operators a leg up in the industry, and that's just not the case. The delivery, the 2 driver model needs to go away. I'm sure we already talked about that. We all feel that way. Social consumption, I think I mentioned to you and you at that last hearing, the social consumption license needs to have an exclusivity period of 10 years, not 3 or 5 for EE and SE applicants. Because as I said at the previous hearing, it takes multiple years to get up and running. It'll take multiple years to get up to 0, even breaking even. And then it'll take multiple years after that to make anything that even resembles a profit. Looks like, do I have more time?
You got
Great.
1 more minute, yep.
The community impact fee should not be 3%. I think it should be 0, but maybe drop it down to at least 1% maximum, because really cannabis businesses don't cause a financial impact to communities. So that's just more extortion. And also, please don't allow sex offenders to work in the industry. I think we've already talked about that, but I reiterate that as well. I'll yield my time. Thank you.
Great, thank you so much. Thank you, Lucas. Next up is Alyssa Nowak, and after Alyssa Nowak is Devin Alexander. And if you could kind of tee up before the next person comes up. Thanks, Alyssa.
Hi, thank you. Thanks, members of the commission, for having us all here today to hear our comments and all the work that you've done on the draft regulations. The intent was great, and I'd just like to make a few comments. As a cohort 1 social equity participant, I feel that the commission should grant a waiver to operators in which host communities are not compliant with the new law and don't want to be compliant with the new law. The commission shall also notify municipalities and their respective council. And if council is not readily available, perhaps KP Law, since they represent a lot of the municipalities in Massachusetts, of the new regulations, and let them know that if the HCA is not in compliance at the time of the renewal, it will delay operators and they will face monetary penalties. Reward municipalities that get the HCA right on the first shot at renewal. I think that's huge. And then also reward municipalities who choose to use the model HCA provided by the commission. Include MOA and MOU in provisions that talk about monetary payments, in-kind contributions, and charitable contributions. Also include MOU and MOA in the explicitly or implicitly a factor considered in a condition of the HCA provisions. In addition to prohibiting host communities from mandating a certain percentage of gross sales, also prohibit municipalities for asking for a flat dollar fee amount. And in addition to the review of HCAs submitted by a marijuana establishment, remove the provision that says if the HCA isn't compliant in the determination notice, they will notify parties that one of their options is to discontinue relations as a host community and a licensed applicant. So you're going to allow a host community to end relations with a marijuana establishment just because they don't want to comply with the new law? What about cannabis operators, especially social equity and economic empowerment cannabis operators who spent their entire life savings on this endeavor? But because the host community doesn't want to follow the law, now the operator is screwed? Failure to submit a compliant HCA may constitute grounds for denial. This is extremely damaging to marijuana establishments. If there's a failure to submit a compliant HCA, instead of denying a marijuana establishment, there should be a penalty to the host community until they do submit a compliant HCA. And then in regards to the equity section of the draft regulations, I believe that municipalities should be penalized if they didn't have their initial policies and procedures in place by July 1st, as required by the legislator in Chapter 180, Section 25. Also include a provision that says if host communities have a cap on HCAs, they don't have, and they have not yet reached their cap, so therefore they still have some available licenses, then 50% of those should go to an equity, social equity or economic empowerment. Currently, regs say only if a host community later decides to allow additional licenses, then the 50% of those should be equity. But I'm saying that if they still haven't reached their cap, then 50% should go to equity. And then my final point would be under the required practices when negotiating with an equity applicant, to put some language in there that says that the municipality will not drag out negotiations. Currently, I've spent $30,000 on attorney fees to negotiate an HCA that I still don't have. And as a social equity and a small business owner, it is draining my pockets. Thank you.
Thank you, and thank you for your thoughtful. You've sent us some very good information, and we appreciate it. Thank you so much. Devin Alexander, and then after Devin is Jeremiah McKinnon.
Good morning, Cannabis Control Commission. My name is Devin Alexander, and I'm the CEO, co-founder, and majority owner of Rolling Relief, a social equity certified marijuana delivery operator in the city of Newton, the city of Newton's first Black-owned business and equity business. I could stand up here for hours talking about all the things that we need to get changed today in this industry, in this state, but I'll keep it brief. My main concern is HCAs today and HCA reform. Last year, Governor Baker signed into law Chapter 180 in August of last year, and it took effect in November of last year. So you guys have a legal state mandate to have the regulations promulgated by November 9th of this year. However, you will not be enforcing this HCA reform until May 2024. That is a 6-month period in between, which leaves it open to more lawsuits, more corruption, more extortion. Now, there are certain associations that claim they are for equity, but that's just a lie. It's all talk. They are not. The marijuana delivery operator license was a license created 3 years ago, and these same organizations spoke out against us and filed a lawsuit against us. So when they claim to be for equity, you can't take that serious. Their actions prove they are not for equity. Now they are nervous over this new reform, and they say it has not been done properly. Come on now, you know that's just not true. You guys have done a great job, and I cannot wait until you guys have control of HCAs, but we cannot wait 6 months. That is just too long. That is literally a year in between when the law took effect, when you guys have promulgated it. It should be November 16th that you guys should have control of the HCAs. I also want to go on record by saying I do not believe sex offenders should be able to work in this industry. Let's move this forward. Let's keep on going. Let's get rid of this low-hanging fruit so we can get to the real important matters, such as the two-driver issue, which has been hamstringing delivery companies for quite some time now. All right. Thank you very much. Appreciate you all.
Thanks, Devin. Appreciate it. Jeremiah McKinnon. Oh, there he is. And then after Jeremiah McKinnon is Frank Shaw.
Good morning, Commissioners. Thank you for allowing me to speak today. I want to keep it brief and allow others to speak, but I want to say I applaud this update. And, laws need change. This cannabis industry is new and we need to learn from the mistakes or, there's a learning curve. So I'm glad that the laws were changed and that these regs are being updated. And this illustrates a collective commitment to making an equitable industry, which I know is it's something that's ongoing. And whether we're talking about 2016 or 2023, rooting our rules in fairness and accessibility is important. And, as medical cannabis advocate, I saw firsthand the process of, host community agreements back in the medical days before legalization happened. So equity does go beyond businesses. This is about people. And from that perspective, representing patients, I wanted to come today to talk about how telehealth has bridged the gap and made access to medical cannabis care more equitable. And patients, it's important that we don't leave patients behind, and because of their disability, their location, or their financial means. The Board of Registration in Medicine in Massachusetts says that a face-to-face encounter between a physician and the patient is not required prior to healthcare delivery via telemedicine. The majority of healthcare providers in the medical program are physicians. So this is how the board that controls and regulates physicians sees medicine. Is the commission defining medicine differently? We have to be in alignment with the changes that have happened in state law since the pandemic started that have made telehealth as equal to in-person care. And by accommodating in virtual visits, we've invited more patients to participate in the medical program and benefit from access. So can we truly transform equity if we are not using this transformative tool? And I know the telehealth waivers are set to expire at the end of the year. Our group feels that this is the perfect time. It's a very simple edit. Please take a look at the final comment that we did send, because we provided draft language to make this edit. And while we move in the right direction with these adjustments, I hope we can do so with a holistic approach. Equity is not just about business dealings, but about patients who find it equitable to access their medicine. And lastly, I will just say that it's not lost on me, this meeting is hybrid. You are accommodating those who cannot make it here today at this time in physical form. Let me just turn it on its head. I've testified in person at public hearings before to the commission. What if you made it so that way I could testify virtually, but someone who's new here today, they had to come here at 10 in the morning. You're seeing how this, so I know there is the waivers coming at the end of the year. I just hope that we can make this permanent. Thank you.
Thank you. Frank Shaw, and then after Frank Shaw is Nicholas Obolensky. Need to get him a chair. Frank, if you need a chair, would you like a chair?
That would be more appreciated.
Thank you. Yeah, again, the table is there for folks who are not easily standable.
I understand. Thank you. Thank you very much. I have a visual problem too, so I got to go slow.
Okay. Again, so there's the timer, and again, and some people have been hearing the beeper and then jumping off. The first beep is yellow, the last beep is when I step in, so. Thank you.
Can you hear me?
Yes, we can. Thank you.
Does it work?
Yep.
Good.
If you want to pull it a little closer, you can pull it closer. There you go.
Thank you. Good morning. Thank you for holding this hearing and allowing me to speak today. My name is Frank Shaw, and since March 2021, I have served as a registered qualified patient advisor on the Massachusetts Cannabis Advisory Board. For many years, I've seen the cannabis industry involved, and from my perspective, this draft represents a big step in the right direction. In the early days, medical marijuana companies had to obtain letters of non-opposition from the municipalities before they can apply for a state license. While these letters evolved into today's host community agreements, it was not uncommon for cities and towns to be more interested in the money, often at the expense of developing an equitable industry. Now, with this draft, the commission will finally review the host community agreements in an effort to establish a more equitable licensing process. This is crucial, as there continues to be a lack of equity in the cannabis industry, which concerns me as a patient and a policy advisor. While some argue at the commission's equity incentives have generally missed the mark, it widely acknowledged that this is especially true for medical program. Equity in the cannabis includes medical too. It's undeniable that the telehealth has made the process of assessing medical cannabis care through equitable means. As patient advisor, I meet a lot of patients. I also speak to a lot of individuals who are interested in getting their medical card for the first time. For first-time patients, the option can be certifying virtually can be a game changer. I'm elderly and struggle with mobility issues, so I understand that getting to a physical location on a given day can be difficult for a number of people beyond myself. That is why I'm asking the commission to update the regulations during this adjustment to eliminate the in-person visit requirement for new patients. Since March of 2020, the commission has waived this requirement, and it is about time that this policy is enshrined into the regulation. This is a perfect time to include this simple yet significant change. The telehealth waivers are set to expire at the end of the year. Please don't forget about the importance of telehealth and the impact it has on making access to medical program equitable. Thank you for your time and indulgence.
Thank you very much, Frank, and perfect timing. Appreciate it. Next is Nicholas Obolensky, and then after Nick is Sean Cooney. If you can be up and ready after Nicholas speaks. Thank you.
Good morning. Thank you, commissioners. My remarks are a little longer than 3 minutes, but I will do my best to tidy them
You can
up.
always submit written testimony.
I've submitted this as well. As I said, my name is Nicholas Obolensky. I'm a partner at Obolensky and Balcom in Providence, Rhode Island, and I've assisted numerous clients in Massachusetts with their cannabis industry municipal licensing needs. And I'm going to focus on host community agreements and the community impact fee components of the draft regulations. There's obviously a lot to say, but due to time constraints, I'm going to focus on the need for these draft regulations as they pertain to community impact fees and social equity program participants to be retroactive. And first, I would like to say that, I talk about the original legislation. The original Section 3D stated that a host community may include a community impact fee for that community, provided that the fee is reasonably related to the costs imposed upon the municipality by the operation of that establishment, and those costs need to be documented and considered a public record. So I think the law was clear on its face then. I think that the only thing that the legislature did was clarified the law as it stood. I never had a doubt what that meant. And I've spent the last 5 years banging my head against the wall, negotiating with municipalities over what they've been instructed by their council, primarily KP Law, what that clause permits. What I'm saying is that that clause never permitted the overreach of municipalities to begin with. And when I hear that municipalities are negotiating in good faith, I laugh, because almost all of my clients have been over a barrel. I've been routinely pushed back on to provide waivers of the town's need to quantify or document its cost, waivers of the right to dispute the fees, waivers all over the place, essentially allowing municipalities to collect 3% of a business's gross revenue carte blanche. And I was rarely very successful and never succeeded in getting a municipality to agree on my understanding of the statute. Now, fast forward to 2022, the legislature finally heard the complaints, recognized the need to clarify the law, and did so. Now, I'll skip the highlights of the ways that it has refined the law. But my point is that although the amendment to Section 3D became effective in November of 2022, I'm still being confronted with municipalities pushing back on these amendments, asking operators to waive certain aspects of the revised law and asking them to sign separate contracts like MOUs or MOAs to circumvent the clarified HCA requirements. Further, I have clients that signed HCAs prior to the law becoming effective, but that are not yet operational. But the municipalities are refusing to amend the HCAs signed prior to the law change to comport with current law. What makes this more egregious is that some of these same municipalities are seeking to take advantage of the benefits of the amended legislation, like accepting 4% in tax revenue from social equity businesses, or getting the 8 years period to collect the impact fees, but they're not giving those same benefits to the operators of the changed law. I find it disgusting. I find it bad faith. These recalcitrant towns have been avoiding finalizing HCAs since the passage of this amendment, thereby hamstringing operators that are hemorrhaging money as they wait for the municipal license, their municipal license approval, because they keep pointing to the draft regulations that are at issue today and say, well, let's wait for the draft regulations to come out. Let's see what the CCC does. I've been dealing with this since November of last year. Towns keep kicking down the road using the CCC as a shield for not fairly entering into these requirements. So I have clients in this position, and I think there's a real need for these regulations to specifically and clearly state that their provisions are retroactive. And I'd like them to be retroactive to 2018 because I think the law was clear then. But at the very least, they should be retroactive to when the law passed in August of 2022 or November of 2022. And no company that is not operational but signed an HCA prior to the change of the law should have to adhere to those old standards. The time that
I'm taking it from baseball to football. So
simply stated, HCAs ought to be in compliance with current applicable law at the time a business becomes operational.
thank you. And again, you have an opportunity to follow up individually with each of the commissioners. We apologize because you're very.
No, it's okay. I
don't know
want.
If anyone has any questions, I mean, again.
I have one. Can you just repeat that last? You said HCAs need to be applicable. Do you mind?
HCAs ought to be in compliance with the current applicable laws and regulations at the time that the business becomes operational. Because you've got people that signed HCAs 3 years ago before the law changed, but they've been spinning their wheels trying to get open. Now everything's changed. It's been clarified, but they can't take advantage because the town say, well, you signed it back then, so it relates back. So they keep using various legal gymnastics to prevent them from taking advantage of the new law. But my point is that they're going to take the 4% tax. They're going to take the 8-year pay period, but they're not going to let the operators do it. So it's patently unfair. And that's, and I think you have the legal ability to make it retroactive at the very least, 2022 to November at the very least, August probably.
Thank you. And again, sorry, again, apologizing in advance to everybody who we're trying to get through all of this, but feel free to reach out. I'm going to drive everyone here crazy, but reach out to us individually if you feel. Obviously, you can put anything in writing, and if you want to have post some additional questions and comments, but we have to do it quickly. So anyway, next up is Sean Cooney, and then after Sean Cooney is Brenda Quintana. Sean, are you here? Sean Cooney? And I don't see Sean Cooney. And again, if there are people who are on the list to be in person, but are actually listening online, I'm trying to think of who they might connect, you know what I mean? There might be some mix up or some last minute decision. So I don't know how they would manage it because we've already closed it. Mercedes, do you have an issue?
I'll touch base with Zoom to see if there's any.
Say it again?
I'll touch base with Zoom and see if we've had any correspondence on that item.
Yeah, could you just see,
Yeah, I was the opposite, actually. I was supposed to be remote.
you were supposed to be online, but you've rectified that with the staff?
Actually, this is good time. I'll just bring you that update.
Okay, great. Again, sorry for the
That's all right.
technical. We're still, hybrid is good, but not always easy. So anyway, so I'm going to assume that Sean Cooney is not here. I don't know what you want me to tell Sean Cooney if he's listening remotely.
You can send an email to the inbox and you can send him the Zoom link.
So to the commission@cccmass.com. Okay. All right. Brenda Quintana. And then after that is Ryan Dominguez. Hey, Brenda.
Good morning. I hope it's okay if I brought my laptop. I don't have a printer. All right. Well, thank you so much for this time. Good morning, Chair O'Brien and the commissioners and other staff and leaders here on behalf of the Cannabis Control Commission. My name is Brenda Quintana, and I'm here to represent the Massachusetts Coalition for Occupational Safety and Health, MASCOSH. It's a nonprofit that supports educational advocacy dedicated to improving the health and safety of workers in the state. At MASCOSH, we are committed to the fundamental belief that all workers should have the right to earn their living and return home alive and well. For close to 50 years, MASCOSH has been working closely with many unions, occupational safety experts, community groups, and workers themselves to advocate and win policies for safer and healthier working conditions in Massachusetts. I'd like to begin our testimony by recalling the untimely and tragic death of Lorna McMurray, a Massachusetts cannabis worker who was only 27 years old. Lorna's death from asthma triggered by workplace exposure to cannabis serves as a stark reminder of the pressing need to improve worker safety in the cannabis industry. We want to ensure that such heartbreaking tragedies never happen again. While OSHA fined her employer $14,000 for failing to provide training about chemical hazard, this alone would not have saved Lorna's life. OSHA currently lacks regulations to protect against the hazard that took Lorna's life. Therefore, it is incumbent upon our state, particularly under the enforcement power of the CCC, to develop and operationalize enforceable rules specifically tailored to the health and safety needs of workers in this industry. To achieve this, Massachusetts needs to take a comprehensive approach to assure the consideration of worker health and safety is integral throughout the cannabis industry. This includes enforceable requirements for marijuana establishments to comply with workplace health and safety standards, integration of workplace health and safety in required worker training programs, and the provision of technical assistance on workplace health and safety to employers and host communities. We commend the CCC for its goal of promoting equity and developing new regulations that will encourage communities that will have been historically harmed to have better access to this industry. That said, it is well documented that immigrants and workers of color are overrepresented in jobs of a higher risk of occupational illness and injury and death in general. As workers of color are already at high risk of illness and injury, the CCC must ensure the unsafe conditions are not perpetuated in this industry. To promote equity, it is critical that the CCC develop concrete measures to protect the health and safety and lives of all who work in this industry. In order to do this, we propose several key areas where health and safety measures can be implemented. The CCC should require a workplace injury and illness prevention program tailored to the cannabis industry. For training, incorporate health and safety and responsible vendor basic core training that includes hazard recognition and controls, emergency response, and worker rights, including the right to report issues without fear of retaliation and proper recording of injuries and illnesses. I'm almost done. I'm so sorry. And we also suggest that they offer technical assistance to small businesses for the effective implementation of health and safety measures. And for host community agreements, it would be great to develop standardized occupational health and safety language to be incorporated into the model host agreement. And so all of that is to say that I do believe, the CCC holds the licensing power to support and uplift worker health and safety. And at MassCosh, we extend our offer to assist in this endeavor and figure out solutions.
And I first of all just want to say thank you. You and I have had a conversation. You know that this has been front and center for a number of us. We're coming up on the 2-year mark.
Absolutely.
Of Lorna dying. We did not know about that as commissioners for quite some time, which was troubling to many of us. And we know that we have a little bit more work that we need to do. One, in terms of creating an anonymous whistleblower system. We're still working on getting some of that done, but also some of the points that you've raised. We've seen some of this in some of the conditions that licensees are proactively filing about training and what they are doing to make sure that they're protecting health and safety. But it's my belief that we have to take a look at what our core training is and make sure that we're doing more on public safety, especially for people working in potentially hazardous situations who don't need to check a license, but they're trained to check a license in this basic service. So that's something that we need to do. It's something I'm very passionate about, and I thank you for bringing that to the forefront.
I just wanted to ask first,
of course.
Thank you so much. I want to make sure we can get in contact with you.
Absolutely.
So if you don't mind, even when you sit down, you just send an email.
Yeah.
Your information, that would be awesome.
I'm happy to leave my email. What would be the best way to do that?
Yeah, just tell us.
My email is brenda.q@masskosh.org. Masskosh is MASSCOSH. And I extend that invitation to the rest of the community here as well. I look forward to find different ways to bring in the workers, other interested community members to find a solution to this issue.
I just want to thank you as well. We were all hit very hard by Lorna's untimely passing. We never want to see a Lorna happen again. And we need to learn more. You had mentioned asthma. We need to learn more about that and cannabis dust and how they are related. And as the chair alluded to, commissioners shouldn't learn about it reading it in the newspaper 9 months after the fact. It's unfortunate, and we never want to see this happen again. So I want to thank you and your organization, and we have much work to do around this issue. So thank you very much.
Thank you.
Thank you all for your time.
Appreciate it. And then Ryan Dominguez, and then after Ryan is Caroline Pino. Hey.
Madam Chair and Commissioners of the Cannabis Control Commission, my name is Ryan Dominguez, and I'm the Executive Director for Mass Cultivate Ed and a current CAB member. Today, however, I'm speaking on behalf of the Massachusetts Cannabis Coalition, which I started this year to help bring together our cannabis, ancillary, and nonprofit partners to push for better policies and pool our resources to collectively write comments, work on social impact, business development, and research that will benefit every cannabis business and community. On behalf of our organizations, I would like to say thank you for your leadership and your work for putting HCA's municipal equity and suitability front and center with today's hearing. I was able to provide written comments previously on municipal equity and suitability, so today I will be focusing my time on the HCA reform, which affects all businesses. We applaud the work that has been done to implement Chapter 180 and protect our cannabis industry in Massachusetts. The regulation changes have done a great deal to promote fairness and give businesses a chance to survive in this tough economic climate. With that, there are 3 main opportunities for us to strengthen the draft regulations and close any potential loopholes which can and will be abused. First, I would like to stress the need and urgency for an expedited implementation timeline for the HCA review process, starting earlier than March 2024 and with a review period that is shorter than 3 months. Second, I would like to urge the Commission to ensure that the HCA review and certification process does not hinder license renewals by exposing them to potential loss of license due to a municipality's unwillingness to enter into a compliant HCA. Third, I would like to underline the importance of stronger remedies for non-compliant HCAs. Remedies such as the equitable relief provided for a location change do not provide a substantial recourse for many businesses and will lead to business closures and unemployment for those currently trying to find their way in the industry. Today, some municipalities have continued to enforce HCAs that would not be compliant with the current regulations. With each month that passes without a review or determination by the CCC is another month of exorbitant fees being charged to our most vulnerable businesses. As you know, pricing pressures and competition have created even smaller margins for our businesses to succeed. And the only recourse that companies have to recoup any non-compliant fees would be through litigation. And in the economic reality that our businesses face, and coupled with wanting to make things work in their host community, that is just not an option. The CCC has an opportunity to send a clear signal to both host communities and businesses. We urge you to do this by moving up the implementation timeline and prioritizing a model HCA soon after the regulations are promulgated. We also ask that you put in stronger protections and remedies for all of our businesses. And with that, I thank you for your leadership on HCA reform, and I thank you for your time here and for reviewing our written comments. And I look forward to talking about this more with you.
Thank you, and look forward to speaking in the future. Thanks very much, Ryan. We appreciate your time. Caroline Pino, and then after Caroline is Fran McGuire.
Thank you, commissioners. I'm Caroline Pino. I'm an economic empowerment designee in Haverhill, and I have a few thoughts today regarding HCAs. STEM is currently in litigation with the city of Haverhill regarding our host community agreement and the community impact fee. And on the advice of counsel, I will refrain from any specific comment about that court case. First, operators will need clarity on when any new HCA changes will take effect and what happens in the transition period. For example, if there is an HCA renewal due between the date the regulations are published and the expected date of enactment in 2024, what guidance should both municipalities and operators be acting under? Should there be a temporary HCA in place until the regulations kick in as per the draft regulations? Second, it is important that the new regulations include language regarding what happens if a municipality chooses not to renew an HCA. Moving or closing a business is a huge expense. And while the CCC may not have the ability to force a municipality to renew an HCA, there may be an underlying legal issue associated with a potential arbitrary and capricious non-renewal on account of the volunteer political whim of the current board of the municipality at the time of renewal. The regulations should address this, and this is an undue burden on the operator if the municipality just decides not to renew. There is no penalty or regulatory punishment for a municipality who has the power, though through this is to just close the business down. There needs to be a provision in the regulations that lays out an acceptable notice period, monetary impacts and penalties, an acceptable timeframe for closing or relocation. Third, there should be clarity and consistency regarding municipal accounting. The CCC must have the process in place and examination authority, penalties, and corrective actions to municipalities to determine real versus fake costs. We have seen examples of municipalities creating dubious expenses and attributing them without any evidence or accountability to legal cannabis. The CCC must be aware of this and must take steps to prevent municipalities from using deceptive spending justifications, including in the area of budget appropriations. I applaud the CCC for considering new HCA regulations, and I'll point out that, as always, the devil is in the details. Thank you.
Thank you very much, Caroline. Next is Fran McGuire, and after that, Cleon Byron. Thank you.
Good morning. Thank you. I'm Fran McGuire from Stafford Green. We're an outdoor cultivator, a tier 5 in Cheshire, Mass. Most people may not know that it's a tiny Berkshire, northern Berkshire town between Pittsfield and North Adams. Route 8 runs right through it. I appreciate that. I'm looking at section 10 and then clause D1, where a marijuana establishment shall negotiate for an HCA, but it doesn't say that host community shall negotiate an HCA. And then I appreciate section 14, clause 31, because it does make the towns establish stuff for like we're a certified minority business entity. But what alarmed me is I have a newsletter from a cannabis law firm, and they're talking about options if either party can't agree on an HCA or doesn't even negotiate. And the option that really alarmed me, it says continued relations as a host community and a licensed applicant marijuana establishment. And then in boldface, he goes on to write, a host community's option to unilaterally discontinue relations should be a major concern for all marijuana establishments. Even a marijuana establishment that is fully operational and is only in its first or second year of a 5-year HCA would be at risk of being shut down by the host community if it is unhappy with the limitations that the CCC imposes on their HCA. Our host community agreement was negotiated 5 years, or not 5 years ago, but when the town board of selectmen was 3 members, and there's nothing burdensome about this HCA except that we have to pay them $5,000 a year, which we have for 4 years. But moving forward, the board has been expanded to 5 members, 3 of which have demonstrated adversity to cannabis per se. And if they come back to us and don't just ignore us or don't even negotiate, what's our leverage? I mean, I'm looking at, clause 31 and section 13 because we are a minority business entity, but what are we relegated to? Lawsuits? I mean, can't the CCC in section 10 D1 say that the establishment shall negotiate and the host community shall negotiate? Isn't there some kind of leverage to put on them so that they will come to the table? I mean, I think the way it's written, there's a door open for cannabis prejudice to enter into municipal governance, and not just because of money. And I know we're talking about a lot of money this morning, but just because of prejudice towards the product can obfuscate and the whole process. And I'm just looking at a doorway where cannabis prejudice enters into the Massachusetts regulated cannabis industry. Thank you.
Thank you very much. I appreciate it. Thanks, Fran. Then Cleon Byron, and after that, Ilya Ross.
Hello everyone. Madam Chair, Commissioners, great to meet you guys. I'm a small business owner, second generation, and doing this host community agreement and time and money is very hard. And I just want to be an advocate for social equity and people who come from a small business who have to take it out of their pocket and understand, time is money and profit and loss is huge when it comes to business. And with the host community agreement, the changes you made are awesome. You did a good job because for small business owners like us and social equity owners, we need this process to go a little bit quicker because the time, there's so many things that can happen in between. We do have real lives in between this also, businesses, children, and things like that. So I just wanted to say that I do have a written statement that I will send you guys later. And thank you for my time.
Thank you for coming. Appreciate it. Thank you, Cleon. Next is Ilya Ross. And then after that is Thomas Dolan.
Madam Chair, if I may, please. Just be closer to the mic. We're getting some feedback from Zoom that folks can't hear. So
Testing. Is that good? Hi, good morning, Chair O'Brien, commissioners, staff. Thank you very much for hosting this opportunity for industry stakeholders to voice their input on these very important proposed changes. My name is Ilya Ross. I am the Vice President of Legal and Corporate Development at LDE Holdings, DBA Trade Routes. Trade Routes is a tier 2 cultivator, product manufacturer, and retailer. As importantly to us, and as a matter of pride, we were the first social equity operator licensed across all 3 verticals. Our principal and a number of our employees have indeed been incarcerated victims of the drug war. And in our few years of operation, we have come to the belief of the immense value, of course, that we're biased in this respect, that legacy operators bring to this industry. And of course, the ability to make this a diverse and inclusive industry, which I know is still a work in process. I think those two factors combined make everyone in this room vested stakeholders in the success of this social equity program. And to that end, we do want to voice support for the commission, particularly in setting, parameters and protocols for ensuring social equity at the municipal level. We've heard comments today that, perhaps more detail may be warranted, more templates. All of these things are true, but we understand these things take time, and, minimum parameters are a great first step. We also support the changes addressing contractual and negotiation requirements pertaining to host community agreements, including certification of community impact fees, the requirement that such fees be reasonably related to actual costs incurred, and a delineation of local fees imposed on non-marijuana businesses as part of the CIF review process. We believe these changes support precisely the type of transparency, accountability, and state-level regulatory protection that can continue to support local communities through the growth of cannabis revenues, while at the same time protecting operators from unduly burdensome and opaque local obligations. I would like to point out one regulatory provision, this is in written remarks, respecting the HCA waiver and any rescission of such waiver contained in 935 CMR 500.180.5I. Specifically, the second sentence of this provision states, an HCA waiver may only be rescinded on commission approval of an HCA subsequently executed and submitted by the parties. To avoid a potential scenario where maybe a municipality agrees to a waiver under the perhaps non-contractual sign agreement that it will be rescinded with a subsequent HCA for a set fee, this contradicts other provisions of the regs, which I don't have time to get into, but is a very helpful enforcement mechanism. There's no, but to enforce it, and this last thing I'll say, I just advise staff in reviewing any prospective waiver rescission to specifically ask questions as to whether any such arrangement was ever contemplated in that process. Thank you for your time.
Questions on that? Any questions? Okay. Next is Thomas Dolan, and then Karin Konarski.
Good morning.
Hi.
Thanks for having me. And I appreciate you allowing me to be here in person, as I do believe it is extraordinarily important to have face-to-face conversations, which is where I am premising my comments and around social consumption in the hospitality business. I am a 35-year veteran of the hospitality business with 10 years in operations and 25 years in asset management and advisory. Also an adjunct professor at an institution here in Massachusetts, and in the process of developing a cannabis lifestyle hotel and hospitality concept and brand. I'm going to first premise social consumption versus public consumption. I believe the terms got conflated in a couple of the listening sessions in the past, and talking purely about the fun aspect of this process, which is consuming it with friends, with family, with each other. And social consumption is not new. It's been around. It's legal today. It's just not legal in a private or public venue. Or I should say it is in a private venue, it is available in your home. In other words, you can have people over to socially consume and enjoy this and have fun. You can have as much alcohol as you want as well, I must add. So this isn't a new concept. The hospitality industry is about personal interaction. It's about social touch. It's about being able to touch you and communicate with you. And it's about the delivery of experiences. That's the difference between the retail industry and social consumption. That's the difference between a package store and a restaurant. It's about that experience. And that's what we want to be able to profess here. And that's the only thing I'm talking about. So when we start talking about social consumption, there are aspects of it that, like smoking, that are intrusive to guests. And there are other aspects that are not, like beverages. So much like the alcohol business, you bifurcate these licenses. Excuse me. Smoking is different than consumption. Beverages are becoming more common, tinctures, edibles, and these things. I think it's personally irresponsible to not allow food in social consumption. I think it's much like alcohol, right? It does help it. I understand the reason for it is you don't want people putting it in the food, right? And they can put it in the food today in any restaurant they want, right? So what difference does it make whether you allow it food or not in a venue? And the imagery of the language right now makes it feel like you're going to visit a friend in prison or a family member in prison. You got to go through this other door. You got to buy it here, go through this other door, be strip searched for all intents and purposes, and in order to go consume it in this sterile room is basically what I'm setting up. I'm talking about comedy clubs. I'm talking about food. I'm talking about music and sports and any kind of table or games. That's what we're talking about. And right now, all of these things need to be fleshed out a little bit in the regulations, especially this bifurcation of licenses related from beverages to smoking. And I know my time's getting short here. Lastly, I would say, based on social consumption, based on the current regulations, there's nothing that I've been able to find that taxes social consumption. Yes, selling to a consumer is considered retail according to CMR, I think 64N 1.1, something to that effect. And that is retail, but it doesn't specifically say that social consumption is retail. In other words, remember, you're limiting the amount that you can sell to 20 milligrams. That's a pretty good amount. But you don't limit alcohol, or the state or Commonwealth does not limit alcohol. Why are they limiting this? Self-regulation is huge. The regulation, the trust of your bartenders, your bud tenders, and whoever else is delivering the product is what you really need. And that's it. We're self-regulated in the hospitality industry. And I will cut off and leave it to that.
We're going to get there eventually.
Yes.
You're going to have another bite at the apple, no pun intended, the table here,
Yep.
to be able to talk to us again on social.
And I will put it in, and I will say there's nothing that prevents anybody from bringing cannabis into a restaurant today and consuming it.
Mhm.
Right? In fact, it specifically says that in the ABCC. You can bring it in, you can bring a can. The smoking aspect is different, and I will differentiate. Thank you very
Thank
much.
you. And again, this is going to be an ongoing dialogue when we start to focus on that
And
issue.
that would be the only thing, is that I would strongly encourage that you consult with hospitality professionals, people in the food and beverage business, people from academia, and people from this industry. That's
We will-
a long time doing it.
We will do that.
Yeah,
Thank you again. Sorry for
Appreciate it.
the.
No worries.
I'm sorry, can you remind us your name?
Thomas Gold.
All right.
Thank you.
Okay, thank you, Thomas.
Okay, thank you, Thomas. Next, we have Kernan Konarski. I'm saying that right? Kernan, are you here? Hope you didn't bail. He left? Okay, thank you. And then Son Adede, I'm really usually good at names. Adede? Am I saying it right?
Hi, how you doing, Miss O'Brien?
Pronounce it for me so I say it right. I'm a bit embarrassed.
No, you did pretty good. You did pretty good. I just became a U.S. citizen, so you can call me Sean now. It's a lot more simple. So let's go with Sean. So hi, Miss Chair, Miss O'Brien. My name is Sean Adedeji. I'm here. We're a small business. Sean, he's amazing, by the way. He just spoke not too long ago. The handsome guy over there in Athol. We own a small business in Athol, Mass. And we own a small business in Orange and in Williamstown. There's a lot. You guys have been doing a really great job. As our preferred partners, we want to say thank you for supporting small businesses like ours. I know that I had a personal life incident that happened because I did go through a divorce, which it was a personal thing. And it was hard for me to separate my personal life from my business life. And I kind of got in trouble. I owned up to it. I give God all the glory. I'm back at work. You see, I got my tie on. I see you looking really serious. Hi, sir. Hopefully you're having a great day. So hey, look. So what we're looking to do, and what we're looking to ask the commission. I know you guys have a lot of work on your table right now. Is seeing what is the step-by-step process. Like, we understand that we're currently suspended. We understand that process, and we've been emailing the commission for about a day plus now. I know you guys are extremely busy. You have new talents coming to the table. You have existing operators that are currently working their butts off, and we appreciate that. I'm just a small business. I'm one man. I'm a dad of a 5-year-old. I actually go to gymnastic class, ballet outside of work. My dancing is impeccable after hanging out with my daughter and her team. It's actually pretty good now. What we're pushing for outside of being a dad, outside of work, is just basically get our store back open. It's simple. We understand the commission is busy. I'm going to leave it at that. I know there's a lot of people that want to speak. I just want to say thank you for giving me a minute plus of your time just to say you guys are doing a good job. We're looking to get back open. We have some deadlines that we have to meet from some preferred partners. And that's one of the reasons why we're wondering what is the expedited process, just so we can meet our personal deadline, because we are a business. No matter what, like, you know, our investors looked at me and it was like, hey man, how much money you have? They didn't even say, hey, are you okay? You want a hug? None of that, right? All they cared about was the money. So as a small business owner, we're just looking to get open. Thank you so much for giving me a minute of your time. Y'all look beautiful, great. Thank you so much. God bless you. Have a good one.
Thank you so much. Thank you. And we have one last in-person to testify. David O'Brien, I don't think that we have anybody else that I have signed up on the list. Now, I will tell you, David will testify. It's our plan to take our lunch break now. That's what I have been asked. And so we're going to make it very, very short. And then we will come back a little after noon for the continuation of the remote. So again, David O'Brien, no relation, is the last speaker here. David, if you'd like to come on up here.
Thank you, Madam Chair. Good morning. Being the last thing between lunch and the rest of everyone's day.
It's only 11:30. It's kind of brunch.
Oh, yeah, okay. Thank you first to Commissioner Roy and Commissioner Concepcion for leading the working group on HCA's. Thank you, Chairwoman O'Brien and Commissioner Roy, for attending an HCA regional roundtable we had last month in Uxbridge to hear firsthand from operators and their daily challenges when it comes to HCA's and what they'd like to see changed. I want to also thank some of our Mass CBA members who came today to testify. And I just want to thank all commissioners for coming to our regional roundtables regularly to hear firsthand for the challenges that operators are facing in Massachusetts. Chairwoman O'Brien, you often ask over the last several months, what are the types of things policy-wise that we can do as a commission to help make businesses of all shapes and sizes more sustainable, more profitable in this ever increasing difficulty of running a cannabis business. Implement the regs for HCA's is the first and foremost thing you can do. As has been said earlier, Governor Baker signed the regs better than a year ago. 90 days from that August date was when the parts of that legislation went into effect. I would ask you to consider, and I'll make some recommendations later, implementing some of the elements of the regulations sooner. Don't wait. A little history is in order. I know folks, the 5 commissioners here, I don't think are around, but you probably paid attention to it. In 2017, the legislature in the conference committee looked at adding host community agreements or community impact fees. The language was cut and pasted from the gaming law, little known fact. And it was intended to cover extra costs that municipalities may incur as a result of hosting a cannabis license. No more, no less than that. Up to 3% of what the proceeds were of a cannabis business. It is run amok. Municipalities have run with that 3%. They've not proven how they've spent that money. Operators have asked for years for receipts and they've not gotten them, which led up to why we have the change in the law. It's a reason why so many people throughout the last several years, including the original Joint Marijuana Policy Committee chairs, Chairman Cusack in the House and Chairwoman Jalen in the Senate, said that municipalities were out of bounds when it came to over collecting what I have called legalized extortion to operate in a community. Several of your predecessors, the original 5 commissioners, were very public about saying that municipalities were overreaching with over collection. You have issued guidance, I think, on 2 occasions as a commission. I think the last time in November of 21, saying that these are the reasonably related categories. I don't think it even filled a page. We've done 2 separate analyses as Mass Cannabis Business Association, the most recent one last spring. Municipalities are taking this and putting it in the general fund and not providing any evidence of how they spend it. So I'd ask you to consider a few recommendations. First, and it's been spoken earlier, make the effective date of the new regulations the first full year of when the law went into effect. So that would be January 1st of 2023. Think of it as similar to what we did with the 280E decoupling applying to January 1st of 2022. The legislature envisioned that the tax benefit could accrue to operating businesses in that year. Do the same thing. You taking a year to get this done with respect shouldn't cost us as operators. If you did an example of a $5 million store, 3% of $5 million is $150,000 a year. That's $12,500 a month. So in the category of 300 plus retailers, many of which are standalone operations, they're paying $12,500 for every month until this policy is enacted. It's a lot of money. So I ask you to consider that as the operative date. I would invite all operators to submit through Mass CIP their HCAs. You have a format. You have an ability to collect this. This is not rocket science. I'm not asking you to look at them all, but everybody, the second you send that out, you would have a stampede of people submitting that electronically. And then I'd ask each of you to take 5 licenses each, randomly select them across the state. Each of you take 5 of them and work with your staff to follow through to see what redlining or marking up existing HCAs for compliance would look like. I'd ask you to issue the model HCA soon, and we remain a resource to you. Thank you.
Thank you very much. And again, sorry to everybody for cutting off testimony. We're just trying to make sure everybody gets a chance to speak. And again, everybody has an opportunity to send written testimony. So we will take a break. It's going to be a very short one. It's 20 minutes of 12 right now. We will start with the online testimony at 12:05. And again, I'll just ask Mercedes, have we shut the door now on people signing up for the remote testimony? Yes, Megan, okay. I got 3 yeses back there. Okay, so at 12:05, we will be back here and then we will be taking the remote testimony. Just giving the staff a chance to kind of fix things. Thanks, everybody. I entertain a motion to adjourn to 12:05. Commissioner Concepcion. Commissioner Roy. Commissioner Stebbins, chair votes aye.
Hey everyone, Mike Crawford. What a open to this regulatory comment period. I'm broadcasting from my kitchen. I got to run actually, but I just wanted to come on because that was just friggin' amazing. We're going to be talking about it tonight on the show. We got a great show today, 8 p.m. tonight with Canton Confidential. We'll be talking about Free Karen Reed with some more fucking random citizens from Canton, which I'm wicked excited about. And after we get our Karen Reed in and we get our interview in, we're definitely going to be replaying some of this and talking about what happened today at the Cannabis Control Commission. Just so thankful for Brenda Quintana. She did amazing today. And I'm thankful for the Cannabis Control Commissioners. I've gone after some of them very heavily. And today I'm going to be quiet or even more supportive of them, especially after today. You might have noticed, like a couple weeks ago, I was talking about doing boycotts and protests and showing up at people's houses. And then I got silent for a few weeks. And tonight we were going to talk about that because I am very happy with what I saw at the Cannabis Control Commission today after the chaos. So we're going to talk about that. Brenda Quintana, You saw David O'Brien at the end, Carolyn Pinot, some great, really good testimony today. And there's going to be more this afternoon. So we're excited to see what happens after 12 p.m. We might be back broadcasting more of that. I want to thank everyone. Subscribe to us, follow us, like us, share this, and be there tonight at 8 p.m. I also want to give MPAA Jeremiah McKinnon a shout out because he did a great job about telehealth. And we've also feuded with them way back really heavily, their organization. But again, we're coming together with people. We have actually been talking to MPAA because a lot of things that they're supporting now, I support as a medical patient. And I think it's time. And he may come on the show too. Someone who hasn't been on the show for like 7 years coming back on. So I'm really excited about this movement today. A few weeks ago, I wasn't, but I'm so glad Lorna McMurray's name was brought up today. And I'm really thankful for especially Chair O'Brien, Shannon O'Brien. I'm also thankful for Ava Concepcion and all of the other folks, Nerys Camargo, all of them, all the commissioners today. So I can't wait to see what is in store for all of us. Thank you so much for Mascosh. If you want to support what Brenda's doing, you can check out our website, midnightmass.substack.com. We have what Brenda is asking people to submit testimony for workers about, commission@cccmass.com. You can send your correspondence to them by 5 p.m. today. Support the workers. Check out midnightmass.substack.com if you want to know what to write to the commission to support cannabis workers. We'll be back again tonight. I can't wait. 8 p.m. Young Jerks. I want to thank our audience, especially all of our friends and supporters for sticking with us. We have so much planned. We're going to do so much this year. We'll see you later tonight and maybe later this afternoon. Hopefully some more testimony will be broadcasting live from the Cannabis Control Commission. But again, 8 p.m. tonight, big show. Be there, Young Jerks. Make sure you subscribe on our YouTube and get the notification for tonight. We'll see you at 8 p.m. with Canton Confidential and more about what happened today at the Cannabis Control Commission.